She just needs an Italian sausage and a corn dog, and that would fix her right up.
This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower.
No, I did.
Good morning. Good morning. Are you Crystal Bogan? And Ms. Bogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes. Yeah.
And any additions or corrections or?
There's a lot of history, you understand, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of criminal
Yes, ma'am.
history?
Yes, ma'am. Yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
Okay,
You can feel the annoyance in that pen right there.
The deferred one.
another issue that I see on here also is the restitution, because it shows 9,400, but then it also, that was from inside the bank, and then it shows 500 from an ATM and 100 from a cash app, totaling 10,000, not 9,400. Is that correct?
And that would have been added on, I don't think that's a bank fee. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
Only thing we knew about
That
was
was
the
all.
9,400 that
I wasn't aware of, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash route. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
just a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all,
I mean, that's a good question. I have no idea because I'm not in the area, but I would think that it's just too much liability. First of all, I don't think she would get a license, but if she managed to do that, I just think it's too much liability for any organization to take on.
were working together. So you're both, and what's the other status of
I
the,
don't have the other status of another person, Your Honor, that's just one that's the charge. I'm not posting on there. But. Okay. She's responsible.
yeah. So I mean, if there was another person and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was one call. Size, whether or not she has a conflict. The backside is not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County? Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely
Not this one.
and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
No, there's nothing.
Well, let's review this together, shall we?
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, And that's the 10-year probation that you're on in 5 different cases.
Okay,
That's not correct.
no, okay.
So how many cases are you on probation for in Sutton County?
It all ran together, son.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am, yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
It don't matter, my life's going on, but.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work, so I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at?
I love it. I absolutely love it. I'm just staying out of her way because it's so fun.
Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you... All right, I'm going to set your bond at $25,000. Go back with the bailiff.
Officer Snyder, Union Gap Police Department.
Nice to meet you.
Well,
Okay. This is give a big shout out to California Body Cam. We're gonna do a little group therapy session on this subset out of California. I don't get California stuff lately. I used to have a good YOLO connection, but I don't see YOLO anymore. Those are the days back in YOLO.
the reason I stopped you is you were passing on the shoulder.
Okay.
That's not legal.
It's not legal?
Nope.
The Discord crew hooked me up. People were behaving in court today. It was outrageous.
Can I get your license, registration, and insurance,
I'll
please?
give you my name and information. That's
You
all
don't-
I have
you-
with me right now.
You do not have license?
No, I don't have a license whatsoever. I don't use the roads in a commercial capacity. Here in Yakima and in Washington, the Attorney General, I'm an attorney, by the way. Here in Washington, the Attorney General has already dictated the aspect that all road usage, well, it depends on if you have a contract or not, whether you're using it commercially or not commercially.
Are we doing the sovereign thing?
No, I'm not a sovereign. I'm an
Okay,
attorney.
so what's your name?
My name is. I'm an attorney for real. I'm not
Okay.
even BSing you. And then also right now is the aspect that
I haven't seen this, but there's no way this guy's an attorney. There's no way this guy is an attorney and can say stupid crap like that. They would beat you with a stick if you said that in law school.
the definitions of both
And should.
municipal and county codes here in Washington.
What's your date of birth,
excuse me,
Cameron?
Just one more. But the aspects here in the state of Washington, first off, here in Yakima specifically, both road and street is defined as open as a matter of right for public vehicular travel. So the legislature has narrowly tailored the legislature not to violate any constitutional rights due to the aspect that it is all about the consent of the governed. Meaning that if I'm using the roads in a commercial capacity whatsoever, then of course, right, there's an issue. But I have no contract with the state. I do not have no driver's license with the state. I have not given up my consent to the right to locomotion and free travel.
Okay.
So,
What's your middle name?
and the middle name is James.
All right, sit tight for me.
Hey, are you aware of Rodriguez versus United States?
No. You don't.
I forgot about him. The $1 trillion subset. who sued for $1 trillion but said he would settle for less. Yeah, I bet you will. You're going to settle for sitting in jail because you're a moron. I don't believe this is the $1 trillion subset, but thanks for the trip down memory lane.
Know what that states as far as.
Nope. What I do know is that you were riding your motorcycle illegally on a public road in the state of Washington.
Well,
And you don't have a license.
correct. I don't need to have a license.
I mean, you do.
No, according to the Washington Attorney General and their opinions, as well as Supreme Court
All right,
Justice.
sit tight for me. No, sit tight for me. No, you don't. No, you don't. I'm not making an assumption. Sit tight for me. Sovereign. 438 on 2.
I thought about doing that one. It's kind of good, but it was so long. It was so long. Maybe tomorrow.
Can you start me a second unit? I'll be at the Hofsteiner parking lot. Negative, just a sovereign. What's up, man?
Yeah, just as a matter of fact as well, like where we was at was in Yakima and not Union Gap, by the way.
I observed you in Union Gap.
And the only place where I actually got over into the side was exactly in front of right in front of Valvoline's, which is actually Yakima.
No, it's Union Gap.
I'm looking at the address, bro.
I happen to work for Union Gap, so I know where it is.
Well, this is right where I did it, right in front of the Dairy Queen.
Yeah, that's Union Gap.
No, it says the address is Yakima.
Bro, it's Union Gap.
Yeah, no, according to the map, it shows all Yakima.
All right. Well, go ahead and sit tight for me up there.
That's actually not a
What's
bad
up?
idea.
I was just gonna say,
Maybe I'll do a hangout tonight.
As far as everything is concerned, like,
I'm behaving myself lately. Let's see how long it lasts.
are you gonna issue the ticket so I can be on my way?
Yeah.
Okay. And are you gonna give any discretion, or are you just gonna give a warning for your boy, or how you
I haven't left the country in 2 months. It's outrageous.
gonna do this?
Oh no, you're gonna get a summons for court.
Oh, you want to give me a ticket?
Yeah.
Instead of just a warning
No, I'm not gonna give you a warning because you just got a ticket in July.
in July?
Yeah.
Yeah. So that's not from you, though.
No, it's not for me.
Okay, so that's what I'm saying.
So why would I give you a warning if you've already been cited for the same stuff that you're trying to pull right now?
Well, because I'm not guilty. That's why.
I mean, you're
If I'm not
driving
guilty, Bubba.
you're driving a motor vehicle without a license in the state of Washington.
Yes, and I've won every time in court. That's
All
what
right.
I'm trying to tell you.
All right, so go wait over there.
Well,
Go wait.
You are guilty and you are stupid. This cop is fun, actually.
Over there.
okay.
Yeah. Go win again. Bonne chance.
438 on 2. Can you give me case number, criminal traffic, no rebat? You can talk to him. You can talk to him if you want.
Is that your bike? Yeah.
I just need to get my citations and go. So Rodriguez versus United States says that the stop is not supposed to be extended upon a de minimis amount of time to issue the citations and let me go because there's no crime that's been committed whatsoever. And actually, I don't have a license in Washington, nor do I have registration in Washington, so I'm not obligated to abide by any contracts. This isn't just something that I'm stating to you. I'm actually an attorney, and I've actually won several times in court or had the cases dismissed from prosecution.
Okay, let's see your law license. Let's see it. Just let me give you a hint, though. If it's you writing, I am an attorney in crayon on some card stock, that doesn't count.
Due to these facts, and I can explicitly show them right now. I have 3 federal cases in law suing police for.
And you will lose all of them because you're a moron. I mock your value system.
Violating my constitutional rights. So I really just like the tickets to be issued so I can be on my way because there's no crime that's been committed or that I've been suspected of either. And this is my private property, and due process states that by the Constitution that my property cannot be taken from me at any point in time unless there's a crime that's been suspected. Because I'm not obligated. I don't have a driver's license here in Washington. The Attorney General both has stated that through opinions, and then both Justice Tolman, the Supreme Court Justice Tolman, Tolman, stating that we have the rights to travel here on the roads. Then in Yakima County, both the municipal and the county codes, the definition of street or road states that the roads are open as a matter of right for public vehicular travel. And I'll pull those up exclusively right now for the municipal code. So that way there's no aspect of dictating that I have to abide by some presumption that y'all state that I have to have a driver's license. That's not true. It's not how it works in law. I know that's what y'all been taught, but that's not how it works on the Supreme Court level. So I like the tickets to be issued and be on my way. This is actually extending beyond the...
This has blown me away since I started doing this. I never knew this. I just was practicing law for, a couple centuries. And then I decided to do YouTube. And I get on YouTube and I'm watching other people's, because this crap never happens in my hearings because I'm dealing with other attorneys. For real. Okay? And then I see all these clowns pretending they're attorneys, which I think is weird. I think it's weird because I am one. And I know it's like it. Pretend you're a rock star. Pretend you're an astronaut. Pretend you're something cool. An attorney is like, okay, it's fine. It's a noble profession, I suppose, but it's just tough grinding work. Why would you pretend? Why would you pretend to be something so mundane? I don't get it.
Time to issue the citations. He's just running through my name right now. He's not issuing tickets. He's just trying to search and conduct an investigation.
Gotcha.
So let me see. Are we in the right drive? Let's get in the right one. Because see, I'm already starting to sweat. I don't want to sweat. So, I need to get my tickets to go. Yeah, come on. Summons, untitled. Where is supporting affidavit, cease, notice. Open as a matter of right. There we go. We'll do a search. Find. Okay. County road. County 8.06.010 definitions. For the purpose of this chapter, the following words and phrases shall have been. County road means every way, lane, road, street, boulevard, and every way or place or part thereof in the county of Yakima, open as a matter of right for public vehicular travel. That does not mean drive. It means travel. I can travel by any way I see fit because I own these roads. That's how this works. So,
Yeah, tell it to the judge.
I need him to issue my citation sign.
That's how that works out for you, dummy.
What all you got for me?
We'll get there.
Hey, look, I wanted to show you something real quick, too, like I was showing. Nunez? There you go.
What's up?
So I got Yakima County, Washington, subsection 8.06.010 definitions. For the purposes of this chapter, the following words and or phrases shall have the indicated meanings. 1, county road. It means every way, lane, road, street, boulevard, and every way or place or part thereof in the county of Yakima, open as a matter of right for public vehicular travel.
Sir, just for right now.
Why do you keep interrupting me? I'm talking to you. He said it's okay.
No, I'm trying to talk to you.
Don't
Just
interrupt
let
me.
him finish his
Okay,
citation. Just let him finish his citation.
Okay, but what I'm trying to say is do not interrupt me. I have not committed a crime, and I am not suspected of a crime. You don't run me. Okay, you're not over me. I am a good person. You don't get
I'm
to.
not saying you're not.
Okay, so don't try and sit here and tell me what to do. I can do whatever I want to do. I don't violate crimes.
Okay.
So until I violate a crime, you
Okay.
have no authority
Look,
to tell me
hold
what to
on.
do. Okay?
You're saying you want to get rolling, right? You want to get going?
Yes.
You don't violate crimes, dummy. You commit them. And you committed one today. And they know it. And they're not confused. And your BS won't work.
Him while he's trying to do
He's
the
doing his
citation.
thing. I'm just letting him know the rules. Y'all don't get
You
taught
don't
the
have
rules.
to tell him his rules. He knows the rules.
He don't. If that was the case, why do I have 3 federal cases? If that was the case, why do I got a summary judgment for $1.2 million right now that's about to get paid out? Because cops don't know the rules. You get taught in the academy some, but you don't get taught what the Supreme Court says. And then you're held liable, and he's held liable. And the person that's sitting there is a visitor that's learning what only he knows is liable.
Yeah, we're willing to take that risk. So shut your hole.
Because y'all don't know how this works. And I'm trying to teach you. I have a huge YouTube channel. You want to write down my stuff? You can get involved.
I'm good.
You don't want to?
I'm okay.
Okay, you're going to be hosted on YouTube, just so you know.
That's fine.
All right.
That's
Well, yeah, I mean, it's like, I'm not playing that. I'm not no small-time guy. This isn't, no, you're going to violate my rights. I'm not trying to be bold. I'm just trying to tell you that we as the public now have AI. You see what I'm saying?
You are the very definition of a small time guy. You are a punk. In the old vernacular, you are nobody. Sitting here spouting nonsense that everybody knows is wrong. Literally everybody knows is wrong. The only good you provide society is you provide views to Law Talk with Mike. And I thank you for that.
We don't get fooled no more. We can easily search and find the case law that applies to any situation. We don't have to go searching for books to immediately find what we need to find. And now that we aren't, we ain't getting our rights violated no more. That's how this works. The days of we're going to violate your rights and you're going to do whatever we say, those days are over with. You can do it, but you'll get fired. Believe me, I've already got 3 of them fired. No longer on the force.
Okay.
Brady's list. Can't even go and testify anymore. So what's the point of giving tickets? See what I'm saying? That's how this works. Like, we, the public, ain't playing with it no more. And it seems like you a good cop, so I ain't got nothing to say bad about you. But, you know, I don't have no contract with the state. Did you see a driver's license?
I saw it suspended.
Wait. I don't have no driver's license. I've never applied, so there's no suspension. You better look again, because Cameron's never applied, and I don't have a picture. So you better write that ticket right, because I don't have no license, brother. They suspended the right to apply. I've never applied. I don't have no driver's license. Never.
So it says right here.
Do you show me
Suspended.
I have a driver's license? Do I have applied? Do you have a picture?
In the state of Washington, no.
Okay, that means I've never applied.
Okay.
If there's no picture, then I've never applied for a license, so I can't have a suspended license. What happened is the state of Washington, through their DMV, which is under the AAMVA, which is a private member association, has put in their system a clarifying number to try and identify me, and then state that my right to apply for a driver's license would be suspended.
Even better.
Well, I've never applied. It's
That's
not
fine.
better.
It is.
How's it better?
Because you're no valid operator's license without ID.
What do you mean ID? I don't need that. I did ID. I gave you my ID.
Without physical identification.
You don't have to have that.
Yes, you do. In the state of Washington, you do. Go ahead and look up the RCW.
The RCW?
Yep.
Let me ask you this. If I
Hey, thanks for supplying us the factual basis for another charge.
have the right to self-govern and I'm free, how am I required to do anything?
That's a conversation that you're going to have with the judge.
Well, see,
Not me.
Well, I won't have it with the judge here because I'll actually move it up to federal court because I don't play with municipalities.
That's
Where's
fine.
the judge here?
Like I said, no, just come on.
He's
You're
talking
recording
back.
right now. Are you recording right
Always.
now? Okay.
So the judge here's
You
nothing.
can't be recording if he's on his computer right now.
I can record anything I can see. You can't tell me that.
That's information you cannot be seeing.
Then he needs to hide it. That's not my fault. What are you talking about? I have the right to record. That's a First Amendment right. You know that, right?
I understand.
Okay,
that,
I can
but
write
that's-
whatever I see. I can record whatever I see.
That's fine.
I know it's fine.
He's writing your citation. Why don't you wait to talk to him once he's done?
Because this is how it works. As soon as you want to hear? As soon as I go and talk to him, he's going to answer 2 questions and walk away and say, have a good day. He's not going to answer my questions after I'm done. That's
He's
all.
not?
No, that's what every one of them do. Oh, we've issued the citations. We don't want to talk no more. Bye. You don't want to answer questions? Have I committed a crime? Am I suspected of a crime? Do I have a contract with the state to abide by the driver's license codes? No. So everything right now is actually a constitutional violation because I've advised him that I don't have a driver's license. He knows that I don't have a driver's license, yet he's issuing me citations in a presumption and assumption that I'm utilizing these roads in a commercial capacity. Because drive, by Black Law's Dictionary and by the federal courts, has dictated that you must be on these roads in a commercial fashion. Do you want to know the exact definition of drive? By the federal government? You want to see it?
Let's hear it.
All right, let's see it.
Which is number 1, wrong.
Moor, 349.
There you go. 1 employed, defined as driver. 1 employed.
Where are you getting this information from?
from Black Law's dictionary. That's how it works. I'm not
That's how it
employed. That's how it works. I don't use these roads in a commercial capacity. I am free to use these roads in any way I see fit because they're open as a matter of right for public vehicular travel. Him, you, all of you, you're presuming that I'm driving because that's all you've been taught. You don't know the distinction between driving versus traveling, which the Attorney General here in Washington has clarified through many opinions. Not only that, you get the Supreme Court justice.
You're driving, dummy. You're driving. It's a privilege, not a right. That's it. That's it. Your right to travel means you can go from California into Nevada without being stopped and harassed and taxed at the border. That's all that means.
Tolman, T-O-L-E-M-A-N, who has stated, you cannot, there's a clear distinction between driving and traveling. I'm traveling. Right now I am in, see, y'all don't understand what's creator endowed right?
You're traveling by way of driving. That's what you're doing. Oh, God.
Don't know? Do you know what natural rights are?
Go ahead and tell me.
I don't need to tell you. That's what your city should be teaching you. What is a natural right?
You know everything. So
I
go
don't
ahead
know
and tell
everything,
me.
but I do know
No,
my
I think
rights,
you do.
and I'm not
It
going to
sounds
allow
like
my
you
rights
do.
to be violated.
All right, man.
Yeah.
So check this out. You're
What's
gonna
up,
get
man?
you're gonna get a court date in the mail for operating a motor vehicle without a.
Show up.
That's fine. Then there will be a warrant issued for your arrest.
No, there won't, because I'm going to send in a notice of appeal on the constitutional violations that have advised you of my rights, that I'm using these roads open as a matter of right for vehicular travel. Then I'm going to put in a notice of demand to remove it to a federal court and change a venue because you're not honoring my rights. There was nobody that was harmed. You have no complainant. You have no verified victim whatsoever. There's no statement of a public complaining. So right now it's you.
So this is all the conversation that you're going to have with the judge.
No, I'm telling you because the body
I don't need
camera's
to
on.
know. You can tell the body camera all you want. I'm telling you that you're going to get a court date for no valid operator's license without ID.
Right.
Because you told me you don't have one.
I don't.
Additionally, I got you for improper passing on the right.
Okay.
And no insurance.
Great. I have a surety bond.
What's that?
I have a surety bond.
Oh, okay.
It's for $30,000.
All right. Hey, you know, if you drive, you can be arrested.
I'm not driving.
But you are driving.
No, the definition of driving
Dude,
is one employed.
that is...
Okay, I'm done. Leave me alone. Cease and desist. I'm not going to argue about my rights, bro. You're not going to dictate when you're saying something. I reserve all rights, including my right to remain silent, and you're not going to take those from me. That's it. I got greater endowed rights. You're not going to violate it. Your presumptions will not hold. Sorry. That's how it works. Not driving. Get the definition right, bro. What's going on? What are y'all doing? What are you doing? You're good? We good?
I'm just waiting for you to travel away.
Why, you gonna pull me over again?
Yeah.
That's harassment.
No, that's another criminal offense.
Okay, what is a crime?
What is the crime?
Yeah, traffic infractions are not crimes, right?
Actually, driving without a valid...
People versus ballot.
Hey, can you just listen for a second?
No, because
driving,
you're trying to presume.
I'm not presuming anything.
You're presuming I'm driving. But you don't know the definition of driving.
You're driving, you're literally, it is written operating a motor vehicle. That
is not a motor vehicle.
Is that a vehicle with a motor?
Okay, do you know the definition of a motor vehicle?
That's it right there.
That is
a
not,
vehicle
dude,
with a motor.
Papa Bear.
Show me where the motor's not at.
Okay, just because you do something, listen, okay, I'm gonna be cool. Let me be cool.
My favorite part of this so far, because we were all pulling for it, is when he point blank asks him, "Are you going to arrest me again?" And he's like, "Yeah, I am. I'm sitting right here." I love it. I love it.
I get it, dude. I get that they don't teach y'all. I get it. I am an attorney. Right. I'm not gonna sit here and lie to you, bro. I am an attorney, bro. What don't you understand? Do you want me to show you the federal cases? What do you want me to do? You want me to show you the millions of people?
I'm gonna tell you that if you get back on this vehicle,
you're not even in jurisdiction. You're in Yakima.
I don't care. I saw what you did.
You don't care. So that's on your body cam. You don't care.
I am dealing with you right now. Let it.
Why? Why don't
stopped
you want to just
for-
uphold my rights?
I'm not. Nobody's interfering with your rights.
You took an oath to uphold the Constitution of the United States. You took an oath to uphold the Constitution of Washington, yet you're allowing statutes that do not override my constitutional rights to dictate how you act because you feel as though you need to have authority over me.
No, I don't.
Then why are you harassing?
Because you committed a criminal
Dude. People versus battle, okay? 1952 states.
Do you want me to get a supervisor over here?
I don't. I
Why?
don't need you
Why
to
don't you
tell
want a
me.
supervisor?
Because I win in federal court. Okay. I win in municipal courts. I don't need you to presume and act like somebody else telling me is going to invalidate what people way above your pay grade says.
Okay.
So, like, that's what I'm not understanding. You're
So
over
what
here
I'm
in
telling
Yakima
you-
telling me that if I drive on
Because
Yakima,
I stopped you for a criminal offense that you committed
Dude,
in
you
the city
keep-
of Union Gap.
You keep saying criminal.
Yeah, that's what driving,
That's just-
operating a motor vehicle
That's not a
without
crime.
valid
That's
operator.
an infraction.
Without ID is a crime.
It's
It
not
is a
crime.
misdemeanor.
The definition of crime is bringing harm to another. That shows the ignorance that you have in relation
No, the
to
ignorance
our
is me
state
arguing with
statutes
you right now.
and our freedom
All
here
right,
in America.
give me 1 second. You can take off. You're good.
I'm gonna get an Uber because you're just harassing for it.
Yeah, get an Uber.
I will.
All right, we're good.
You can leave out of Yakima. This ain't your jurisdiction.
Actually, right over there is.
This ain't.
Okay.
Okay. November 10th, somewhere in California. I wasn't paying attention to the towns. If I have some peeps who know how to get a hold of that, I doubt it. But if there's a stream, I want to see this guy's court date in the worst way. I really do. I really do. If I have any California people, work your magic. Figure something out. Make it happen.
We're set here today in this matter for a motion hearing, a four corners motion hearing. Times the criminal complaint, which is a 38-page criminal complaint.
Okay, everybody sent this to me. I'm using it from, I have to give a shout out to Court Uncut. I suppose I could have hunted down the feed and found it, but we've got it right here. And a link to Court Uncut in the description below if you want to see the clip without me talking over it. I haven't seen it. What I'm told is the prosecutor gets out of pocket, and it's really annoying. And I thought, well, all right, fine. But I had so many people send it to me, I felt compelled to just do it.
In this matter, however, with regards to that, there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 charges in that criminal complaint that does contain 38 or 36 counts, criminal counts, but 12 of those counts relate to defendant Robert English. We are here today for the court to hear any arguments to supplement the briefs because again.
Oh yeah, you had to see the Eric Martin moped incident. Go look at that when they pull up this huge flatbed to take his little moped away. It's fantastic.
This is I want to say a complex, or it has a lot of facts and things alleged in the criminal complaint as well as in the arguments. So I am going to start with Mr. Harrington. This is your motion. Again, I have thoroughly read your brief along with the criminal complaint. As it relates to this case and any argument, what would you like to state?
Judge, nothing. I'll rely on my brief except anything that I quoted in the brief, cited in the brief, was based upon either a review of the cases that I cited or the jury instructions. I'll stand on the brief. Thank you, Judge.
All right, thank you. Mr. Schmidt?
There's a reason why the test for adequacy of a criminal complaint is described as common sense and not hyper-technical. If the complaint was only one sentence long and the one sentence was 4 people who reside in Burnett County reported their house was broken into, damage was caused with the breaking in and stuff was stolen, and the stolen property from all 4 were found in Robert English's bedroom, that would be an adequate complaint. This complaint actually contains that information as well as a plethora of other information. The court has already found probable cause for all 12 accounts when it issued the arrest warrant. Attorney Harrington has not pointed out anything.
What? I've got fashion issues. Fashion issues here. What the hell does this guy have on? It looks like he's got a long sleeve t-shirt and a vest. What is that? and it's green. I mean, I guess that's not illegal, but it's, I can't say any of the words that are coming to my mind right now.
And I think the court missed. Thank you.
All right, Mr. Harrington, any reply?
No, I'll stand on the brief.
All right. All right. Again, the court has reviewed both of the briefs that have been submitted by the parties in this case. First, the court must address the issue of the arrest warrant and the argument that the court has heard that the court found probable cause when it issued the warrant. This is not entirely accurate. The court did find probable cause that a crime was likely committed or probably committed, but not that a felony was probably committed or which of the crimes could have probably been committed. And there's a difference. A preliminary hearing would determine whether or not there is enough facts or evidence alleged, even with inferences to the state, to determine whether a felony was probable.
I mean, it varies by judge a little bit, but I've always said this: you got to wear a suit where I go to court. You got to wear a suit, or they'll tell you to get yourself straight. Or there's something like on one occasion I remember I had a flight delayed and I showed up at I was supposed to go home and I couldn't. I had to go straight to court from the airport, and I didn't have a suit. And the first thing I did was explain to the judge, and they're like, okay, that's fine. And it was like a status hearing. But I wouldn't be surprised if they said, go change and come back. I'll reset it. Like, that's what you're dealing with. And then, I don't know if it's still this way, but back in the day, in federal court, literally, you had to wear a suit and either a white shirt or a light blue shirt. Those are the only two colors allowed for a man. Period. End of statement.
Committed. Whether or not the burden has been met with an arrest warrant of a crime being probably committed, it's determined about the facts alleged, and the court did determine that a crime was probably committed and issued the arrest warrant. Second, the court has thoroughly and carefully reviewed the criminal complaint multiple times while examining both of the submitted briefs. The court has reviewed the voluminous communications within that criminal complaint, which would be text messages between the co-defendants. Those written communications among the parties discuss potential burglaries, which then would give the inference or the connection to the criminal damage to the property and perhaps possession of stolen property or misdemeanor theft, moving of property. However, those conversations, specifically in reviewing each of those texts very specifically, those conversations do not implicate Robert English in any of the burglaries, which would then connect to the criminal damage to the properties, only that they may relate to the probable possession of stolen property or movable theft or theft of movable property. So in the court's review, I cannot find the evidence or the facts presented in the criminal complaint to connect Mr. English and the commission of the burglaries and the connection to the criminal damage to property. Could Mr. English could he have possibly known about the burglaries? Yes. Could he have possibly helped in committing those burglaries? Yes. But in the review and as the facts and statements and the specific details are laid out in that criminal complaint, reviewing the criminal complaint and what's laid out in detail in that criminal complaint, it would only be speculation or conjecture because of the close connection Mr. English has to the co-defendants. One of the co-defendants is his girlfriend of a significant long period of time, and the other co-defendant is her brother. But there is that close connection in those written communications as to the likely stolen property and it being in possession of or going to be or something to be done with probably with Mr. English. There's a connection to that. Even as stated in the criminal complaint, in reviewing and looking for the conspiracy requires a mutual understanding to achieve a shared criminal goal and to work together to carry out that criminal plan. There must be some type of either words or actions or intent by the defendant to complete that crime. In the criminal complaint, as again, it is laid out and described in specific detail, the court can't find anything that indicates a conspiracy without having mere speculation or conjecture. This is insufficient for the court to link the defendant to the crime of burglary or to the relation with the crime of criminal damage to property. Although the state does correctly state that conspiracy does not require the co-conspirators to have an explicit or formal agreement, meeting, or even know each other, there still must be more than speculation or strong opinion or belief to link the parties to committing a crime like burglary or criminal damage to property. The details and the specifics as related to the burglary and then the criminal damage to property as outlined in that criminal complaint in the court's review does not provide sufficient inference to connect Robert English to those acts. This is in contrast to the court's review with the allegations of the possession of stolen property, theft of movable property, those and the conspiracy to commit the misdemeanor theft as a party to a crime with that movable property. The court determines that that criminal complaint contains enough facts and specific details to reasonably believe and probably believe that Mr. English did commit or co-conspired to commit those crimes, allowing those charges to move forward. But with regards to the burglary and the criminal damage to the property, the court cannot find enough to connect, even with an inference, without mere speculation or conjecture, to connect Mr. English to those crimes. So I'm believing you understand that the court is saying with regards to the charges, the court can only find enough to connect as it relates to the conspiracy to commit misdemeanor theft as a party to a crime with the movable property. So I believe that is only counts 6, 15, 24, and 33. Mr. Harrington, you look like you want to say something.
I haven't thought through what I want to say, because I think those are all misdemeanors at this point, aren't they?
They are.
I guess, as I recall the rules, Mr. Schmidt has the opportunity to amend the complaint.
He does.
Rather than a dismissal. And I guess I want to know how long it's going to take him to amend the complaint. And where we go from there, suggest that maybe the court set this for a status.
I'm not going to amend the complaint. We need to do the prelim. We need to get this case moving. One of his co-defendants has invoked speedy trial.
It's fair enough. We'll set it for preliminary exam. I have time. If the court is finding that everything except 6, 15, 24, and 33, the complaint lacks that. The motion is an attack on the personal jurisdiction. I think there has to be an amended complaint. These are misdemeanors. We're not going to have a preliminary exam on misdemeanors.
We would not.
I thought the court dismissed the crim damages.
And the burglary.
So the court found probable cause to believe that Robert English was knowingly in possession of stolen property from the theft, which is an essential part of the conspiracy, but would not find the burglary and crim damage that were necessary for the theft, even though the conspiracy jury instruction says he doesn't need to know about those or be part of them.
I think that's precisely what the judge found, and I agree with that.
Exactly what I found in the review of the criminal complaint. And again, you do have the ability to amend the criminal complaint. I could find, and again, in reviewing the jury instructions for conspiracy, it requires at least a mutual understanding and a shared criminal goal to work together to carry out a criminal plan. he would need to know that the burglary was going to be in existence. And I can't find that there is any connection.
It does not require that you all have the mutual understanding of the same crime, just a criminal purpose. That's why the jury instruction reads that.
Again, I can't find in the facts, especially in looking at the text messages.
Okay, so far I understand why the prosecutor's cranky. Everyone's telling me that he's out of hand and he might get there. He might get there. But I'm not saying the judge is wrong, but I understand why the prosecutor doesn't like the ruling. And he's like, you are really splitting hairs. You're saying we've got enough for most of the conspiracy, but not all of it. Come on. And it's all logically followed, and I don't need to make it. I don't know. I'm not getting in the weeds on what's required in Wisconsin criminal law at this point, but I see where he's coming from so far.
And the communications between the co-defendants that Mr. English was involved in the criminal purpose of the burglaries. Did he possess the stolen property? Probably with the facts.
That's what I'm getting at with the conspiracy in this. It's really all or nothing. If the court believes that he was part of the theft, as in he knew the property was stolen and possessed it, he's also party to a crime conspiracy on those others. It has to be all or the other when it's all part of one scheme.
But not necessarily. There could be a scheme. I don't see a scheme here. I see any individual could receive stolen property from their friend Joe. Joe could say, hey, dude, I stole this. I got this. Let's sell this. Doesn't mean that the guy was a part of the decision to steal the property.
Then the court couldn't bind over on the theft because that has a knowing element too. That's the problem.
Well, I find that there's probable cause to believe that he was in possession of stolen property and knew that it was stolen.
So is the court actually dismissing all counts then? Because we didn't charge receiving stolen property.
Again, you can amend if you wish. I'm saying there's enough probable cause to believe a crime was probably committed. What that crime is and how it's laid out is for the state to prove. I'm seeing that there is at least enough to determine probably he was involved in the conspiracy to commit the misdemeanor. Well, to have the stolen property. He had stolen property. So if you want to, I can dismiss all counts.
I am not amending and receiving stolen property. If the court is not finding probable cause for all three counts, that's what I'm checking.
Mr. Harrington? If he does not want to proceed with the other misdemeanors that are stated.
I didn't charge receiving stolen property is a thing. The court's saying it's only finding probable cause for something I didn't charge is what I'm hearing.
I think the judge addressed me. I'm to answer the question.
Yes, Mr. Harrington.
As I mentioned, the rules require or give the state the opportunity to amend where a court finds that there's not facts sufficient in the criminal complaint to impose the jurisdiction of the court over this particular defendant.
I don't see why he doesn't just amend, but I get his point. I do.
The state has that right by statute. What Mr. Schmidt is arguing, the court decided that there aren't facts sufficient to connect those inferences that they want to have connected for the felonies. If, as I understand the court's decision, the court found that there is no basis for the conspiracy as it relates to the burglary and the criminal damage to property, but that there is for counts 6, 15, 24, 33, those are misdemeanors. If Mr. Schmidt wants to amend, fine. But I don't view that we need a preliminary exam for those particular crimes. They're misdemeanors, even if it's misdemeanor.
And that's the court's view is I find probable cause that a crime, a misdemeanor crime was probably committed by Mr. English. There is definitely enough there to connect that. And you agree, Mr. Harrington? Yes, you're nodding your head up and down. Yes, you agree. And even in your brief, you agree that there is enough to say Mr. English probably committed.
There's probable cause to believe.
Correct. There's probable cause to believe that he did commit misdemeanors. Whether or not the state wants to continue and to pursue the misdemeanors as charged, that's a determination for the state. The court is not dismissing those misdemeanors. As stated on the record by Mr. Harrington, and I have them written down somewhere as to what they are, but I don't have them, I don't know where I wrote them down on which. 15, 18, no.
6, 15, 24, 33, Judge. Those are the ones you recited on the record.
Correct. Those misdemeanors stand in the court's review of determining probable cause that a crime was probably committed by Mr. English. The other allegations, the court cannot find any connection as laid out in the criminal complaint. But again, the state has the ability to find other information or to put other things in that criminal complaint that would tie it to a conspiracy for criminal damage or conspiracy for burglary. I just can't find it. And I'm going to tell you, I reviewed that 38-page criminal complaint at least 3 times, perhaps more.
Here's the issue of confusion I'm having. I'm hearing the court saying it's finding probable cause for the counts that are misdemeanor theft, movable property, where the state's alleging that Robert English took property out of the home during the burglary.
That is not what the court is saying. The court is saying, just like any preliminary hearing, when I have
This is not a
Mr. Schmidt, it's not, but this is my example to show you. In a preliminary hearing, the court has to find probable cause to believe a felony, not the felonies that are charged by the state, because sometimes the state charges them wrong, or sometimes the state doesn't add additional felonies that they
I'm on water at the moment.
can find. In court's review of a complaint as it relates to misdemeanors, and Mr. Harrington can tell me if I'm wrong, in review of a misdemeanor criminal complaint with misdemeanor charges, the court has to determine if a misdemeanor crime was probably committed by the defendant, whether or not the state has accurately and correctly charged the crime that should be charged. Am I not correct, Mr. Harrington?
You're absolutely correct, Judge.
Absolutely correct.
I don't believe that's correct. I think when it's a four corners motion, you challenge the actual counts in the complaint, meaning the court's not deciding whether or not a misdemeanor occurred when it reviews the complaint. It's deciding whether there's probable cause for each of the counts in the complaint.
Mr. Harrington,
That is how 96801.
if you want me to dismiss all of the counts, I surely can, but I'm finding that there is probable cause to believe Mr. Robert English has committed a crime, and in review of the criminal complaint, as it is stated with every single word in there, probable cause to believe he committed misdemeanor crimes.
And my understanding is what I'm trying to articulate is what I'm hearing from the court is the probable cause for the misdemeanor the court is hearing is not the misdemeanor theft we charge. It's receiving stolen property.
I can't even say that. Even in a preliminary hearing, I can't say I find probable cause that a burglary was committed, because the law says I have to determine probable cause of a felony or probable cause of a misdemeanor. If you believe and you want to have the court dismiss all of the counts as it relates to Mr. English, because the court found probable cause for a crime, but you're believing that with the four corners, that means the court has to dismiss all because the court's looking at, did he commit that crime? You're putting the court in the spot of being a jury for the court to determine if the facts of the case relate to whether or not Mr. English committed misdemeanor theft, moving stolen property. I am not the jury. Right now, I am just here to determine probable cause to commit a crime. I find probable cause Mr. English committed misdemeanor crimes, at the very least, as it's alleged in the criminal complaint. What the state wants to do with it, the state can do with it. But as to those other counts not stated on the record, I cannot find probable cause. So, as of this court's review, all counts except 6, 15, 24, and 33 are dismissed. Whether the state wants to pursue the theft of movable property or to amend to something else, or to amend the whole criminal complaint to find other connections with Mr. English and the burglary and the criminal damage to property charges, the court or the state can. But that's what I'm finding. And again, I think my review and my understanding of case law, my understanding of the statutory law, I believe I'm correct. And again, I'll hear Mr. Harrington. What do you think?
I agree with you, Judge.
The problem I'm running into is if the court is just finding if that probable cause of the misdemeanor exists, I don't know why the court dismissed the crim damage and kept the theft, why it did make a decision to choose one and not the other.
Criminal damage is so connected to a burglary because you're alleging that he had the conspiracy to commit that criminal damage of breaking a door or breaking a window or breaking those other things to damage that property. If the court cannot find a connection other than speculation or conjecture that Mr. English, with the facts again, as stated in the criminal complaint, conspired to commit a burglary of a building, the court cannot find that he conspired to commit criminal damage to property. Again, as to the other property, the property that is of issue here, the court can find probable cause he committed a crime. Again, if you want the court to dismiss all of the counts, I surely will.
I want the court to find there's probable cause for all. I'm being careful with my language because I'm trying to figure out if this is a final order finding no probable cause for any of the counts, or if it's, and that the court thinks there is probable cause for some misdemeanor not in the complaint, or if the court's finding that, because the state did not allege receiving stolen property. The state
Correct.
alleged that.
Exactly.
the
I'm going to
state-
tell you, okay, I find probable cause that a crime was committed. I find based upon the charges that are charged right there, removing the ones the court cannot connect to Mr. English, that there's probable cause to believe a crime was probably committed and it relates to the charges that are filed. Again, whether or not the state charged the correct charge, the correct criminal charge, or what the state can prove to a jury is for the state to determine. But I'm not dismissing counts 6, 15, 24, or 33 unless the state asks me to dismiss them all. Then I will. I have no problem doing that.
I do not. I believe there's probable cause for misdemeanor theft. Thank you.
All right, thank you. Then those counts stand. Anything further?
I have to chat with Mr. English about some things. I'm not sure what this does with the trial on with these other two defendants, frankly.
Well, that's for you to talk to the state and that's for that to be figured out. And here's the thing. I understand that you represent Mr. English. The court needs to have the speedy trial. We're having the speedy trial when it's set. If you can't be here, Mr. Harrington, Mr. English, and that he needs to be a part of that trial, Mr. English will then need to get a different public defender.
Thank you, Judge.
Oh, see, this is why I don't trust you people. That was learning stuff there. That was some learning stuff. Okay, so we have a close call on probable cause issue. I see exactly where the judge is coming from. I'm comfortable with probable cause to the extent of this, not the burglary, not the actual stuff, just the after the fact receiving stolen property and all this kind of crap. He's saying, yeah, you don't need to. You're just part of the conspiracy generally, and you're on the hook for all of it. I don't know. That's a very specific Wisconsin law standard that I'm not familiar with. I literally don't know which of the two of them is right. That doesn't much matter. It was sent to me in the context of this prosecutor's out of hand. I did not think the prosecutor was out of hand, if you want my assessment of that. He thought she was wrong. He stated it respectfully multiple times. And why? She still ruled the way she ruled. Who's right? It doesn't matter. This stuff is close. It doesn't really matter. They both make sense. I'm not sure what the rule is. So they both made fine arguments. I'm just not familiar with the rule, so I'm not going to sit here and pass judgment on which one of them was right. I'm not. But the prosecutor the prosecutor was like, I think you're so wrong that I want you to dismiss all of it and it should all be on you. But she's like, no, I'm not having that. I'm dismissing what I'm dismissing, and if you want me to dismiss the rest, you can motion for that, but that's not my ruling. You have prosecutorial discretion. You can dismiss. If you ask me to, I'll do it. But I'm only dismissing what I think needs to be dismissed. Be that right or wrong. Then the other issue is, I don't know how speedy trial works into it because there's co-defendants and they're going to trial, whatever. But I mean, if he wants to, he can just amend the damn charges. If it matters that much to him. For some reason, he's taking the position that I'm not amending these charges. Maybe there's a good reason for that. Maybe there isn't. I don't know. He said because of speedy trial, but I don't see that. But that doesn't mean it's wrong. That doesn't mean it's wrong. But that's no way to end a happy hour right there. That's no way to end a happy hour that started with Judge Middleton saying she needs an Italian sausage or a corn dog. And that'll straighten her right out. All right. Behave yourselves. Be good. Get an Uber. Do not get arrested. I'm not bailing you out.